And we would like to welcome back John Rizvi, that is. He is known as the patent professor, and he is here to talk to us about a situation involving Meghan Markle. Good morning, John. How are you?
Yes, good. How are you?
Doing well, doing well. So this situation involves the Duchess of Sussex, and she's got trademark troubles. What's happening?
Yeah, so she's got a new brand that American Riviera Orchard that she applied for, and there's serious issues with it. One is, of course, the trademark office is taking the position that it's geographically descriptive. And in fairness, they're not going to issue a trademark to a geographic area. American Riviera is a nickname for Santa Barbara, California, and it's not fair. That's a policy behind this rejection. Is it's not fair for one company or individual to monopolize a geographic area and get a trademark on it. So that's one issue. The other one is that there's a fruit company, a purveyor of fruits, Harry and David. Mm-hmm. Of course, no relation to Prince Harry. It's just a separate company, Harry and David, and they have a peach fruit product known as the Royal Riviera. And they're filed a protest saying that their consumers are going to be confused between the mark American Riviera Orchard and Royal Riviera. So there's two really serious trademark issues that her brand is facing currently.
And so this is about I'd hate to be so whatever, but she's in a jam, and this is about jam, right?
Well, it's about jam because that's one of the product lines that she has applied for a trademark for. But the trademark is incredibly broad. She's applied for several classes. Dog biscuits, pet products, cosmetics, home decor, kitchen items, linens. It goes on and on. Kitchen towels, gardening tools. So she's applied in for a ton of different classes, and that, of course, opens up a lot more risk because anybody that has an existing trademark that they feel is going to be harmed can file a letter of protest, and later on, if the trademark office decides to publish the mark, they can file an opposition. So, certainly filing in this many different classes of goods and services is always a risk. You typically try to focus on those goods that you intend to bring to market immediately. Now her jams they're still not available for purchase, but she started sending samples out to social media influencers and celebrities to try to create buzz. Unfortunately, the buzz that's being created is really about her branding and the ill choice of a brand name because it's facing a lot of obstacles even before the product's actually launched.
So, and this has also gotten the attention, this whole situation. It appears to just, really this is all about jam and Harry and David, and a lot of us know who Harry and David is. That's Fruit of the Month Club and all that kind of stuff. But she has had to hire a patent attorney. Is that right?
Yeah. So, actually, brands are protected with trademarks. So, trademark attorneys help secure brands. And I don't really know whether there was what the advice was prior to filing, whether the attorney advised that this would be a risky brand to proceed with, and they decided to proceed anyway, or whether there just was no warning that these issues could come forward. But I can't see that. I mean, it's so clear. A simple search of the trademark database would have revealed Royal Riviera, even if someone was not familiar with the Harry and David product. But that's why you do trademark searches before filing, to try to see if there's anything out there that could possibly cause problems for you. And anytime you use the name of a city or any type of geographic description in your trademark filing, you face a clear risk of a rejection because you're trying to seek exclusive rights to a geographic description, and the trademark office believes that that area should be available to all competitors, that one person should not have exclusive rights to, for example, the American Riviera.
And so now can she get a patent at all, or what does she have to do? What's next?
Yeah, so the protest is not binding. So just because somebody opposes your trademark or files a protest doesn't mean that the examiner has to abide by that. But certainly they have to pay attention to that, and it's their job as a trademark examiner not to grant future trademarks to anybody whose trademark is going to harm and confuse existing consumers. So one thing she would have to show if she wants to overcome this protest from Harry and David is that consumers are not confusing the name for their peach product, Royal Riviera, with her product, American Riviera Orchard. So she's going to have to show there's no confusion. It's going to be an uphill battle for her because Royal Riviera is, of course, implying that it's royalty, and Meghan is now part of the British royalty. So perhaps she's trying to separate herself from that. But as far as the consumers are concerned, that's never going to be something she can get away from. She's always going to be seen as being associated with British royalty, and that makes her case of trying to show that there's no consumer confusion even tougher. Because she is royalty, she may be associated with Royal Riviera, and their consumers might think that American Riviera is somehow associated with Harry and David, and that company has a right to not have that association made. So they have a really strong case in their protest. If I had to speculate, I would think that she is going to go back to the drawing board and rebrand with something else.
Would banished royalty work?
That's a good suggestion. It may be. I mean, I don't know. When you say work, it may be okay from a trademark standpoint. Now, I don't know if consumers are going to flock to purchase, but that's something that time should tell. I mean, what I would say is if before rebranding that she seek the advice. Maybe she has the trademark attorney advising her, but certainly follow that advice because you can't. I don't know if the consuming public is going to provide that many more chances for branding. So she's got to get it right the next time through. I don't know. There's no formal 3 strikes or you're out, but certainly it starts the company out on a terrible initial impression, and their first steps look just extremely disorganized and not well planned, which is not what you want when you're launching a new product.
And that appears to be the way that her whole brand and luck is going these days. It appears. I don't know. From stories that I've read, she's having troubles in a lot of different areas, apparently. So we will keep watching. We want to thank John Rizvi. He is the patent professor. He's an adjunct professor of patent law at Nova Southeastern Law School in Florida, and he has authored 2 books on patents. John, where might our listeners find you?
Yeah, so our speaking of trademarks, our trademark is the Patent Professor, and you can find us pretty much anywhere on social media. Type in the Patent Professor. We're on Instagram, Facebook, Twitter, LinkedIn, and our website is thepatentprofessor.com.
John Rizvi, thank you so much for being with us.
Thank you. Always a pleasure.